Hello everyone. Our group will report Katarungang Pambarangay. The Katarungang Pambarangay was originally governed by Presidential Decree number 1508, otherwise known as the Katarungang Pambarangay Law, which was signed by President Ferdinand E. Marcos on June 11, 1978. Later, it was repealed by Republic Act number 7160 or the Local Government Code of 1991. On June 1, 1992, the Department of Justice promulgated the implementing rules and regulations for the Katarungan Pambarangay Law under RA 7160. These rules govern the establishment, administration, and operation of the Lupong Tagapamayapa and the Pangkat ng Tagapagkasundo, as well as the procedures in settling disputes among barangay members through mediation, conciliation, and arbitration. The Katarungang Pambarangay is a community-based mechanism for dispute resolution. It covers disputes between members of the community and involves the punong barangay and other members of the community as intermediaries. It is aimed at achieving peace and harmony within the community and providing accessible form of justice for community members. The court mentioned in the case of Galuba versus Laureta that the primordial objective of the Katarungan Pambarangay Law is to reduce the number of court litigations and prevent the deterioration of quality of justice which has been brought about by the indiscriminate filing of cases in the courts. While in the case of People versus Caruncio Jr., the court mentioned that the barangay justice system was established primarily as a means of easing up the congestion of cases in the judicial courts. The barangay justice system provides an alternative mode of dispute resolution to the costly and lengthy process of settling disputes in regular courts. Instead of going through the very technical procedure of filing formal pleadings and presenting evidence in courts, the parties of a dispute are given the opportunity to try to talk to each other and resolve their disputes amicably. Simply put, the barangay justice system provides a friendly, inexpensive, and speedy forum for the settlement of disputes where the parties can freely explore options for amicably resolving their disputes without resorting to the courts.
The proceedings before the lupong tagapamayapa or the pangkat ng tagapagkasundo of the barangay are not judicial proceedings. As discussed, the katalungan pang barangay is not considered as judicial proceedings. It was made to reduce numerous cases filed and heard before the courts. Its purpose is not to determine who is right or wrong, but to come up to possible settlement outside the court. The lupon and the pangkat do not have inherent adjudicatory powers. They resolve through amicable settlement, conciliation, and arbitration. Considering that Katarungang Pambarangay is not a judicial proceedings, they are not suited with adjudicatory powers or the power to make or order judgment. All cases before the Katarungang Pambarangay should resolve through amicable settlement, conciliation, and arbitration. Where the case is covered by the Katarungang Pambarangay law, the compulsory process of arbitration required therein is a precondition for filing a complaint in court. Although the Katarungang Pambarangay is not a judicial proceeding and don't have adjudicatory powers, but it performs an important or integral part in the judicial process. As cited in the case of Agbayani versus CA, all disputes are subject to barangay conciliation. Prior recourse thereto is a precondition before the filing of complaint in the court, except otherwise except by the statute. No complaint, petition, action, or proceeding involving any matter within the authority of the Lupon shall be filed or instituted directly in court or any other government office for adjudication unless there has been a confrontation between the parties before the Lupon chairman or the Pangkat and that no conciliation or settlement has been reached as certified by the Lupon secretary or Pangkat secretary as attested by the Lupon or Pangkat chairman or unless settlement has been repudiated by the parties thereto. It was stated in Section 412 Local Government Code of 1991. It is true that precise technical effect of failure to comply with the requirement of Section 412 of the Local Government Code on barangay conciliation is much the same effect produced by non-exhaustion of administrative remedies. The complaint becomes afflicted with the vice of prematurity, and the controversy there alleged is not ripe for judicial determination. The complaint becomes vulnerable to a motion to dismiss. It was held in the case of Aquino versus Aure. A motion to dismiss a civil complaint may be filed if the condition precedent for the filing of the claim has not been complied with, as stated in Section 12J, Rule 16 of the Rules of Court. All cases requiring prior referral to barangay conciliation must contain set statement of compliance. Where there is no showing of compliance with such requirement, the complaint shall be dismissed without prejudice on the court's initiative or upon motion by the defendant. It may be refiled only after the requirement has been complied with. It was stated in Section 2, Rule 3 of the Administrative Matter number 08-8-7 of the Supreme Court.
Good day, everyone. I am Jairo Rodriguez, and I will be discussing the cases covered by the revised Katarungang Pambarangay law. So, as a general rule, all disputes are subject to barangay conciliation pursuant to the revised Katarungang Pambarangay law, and prior recourse thereto is a precondition before filing a complaint in court or any government offices. So, what this tells us is that there is no specific coverage of subject matter that may be brought for barangay conciliation. The effect of non-compliance with this law is prematurity or non-exhaustion of administrative remedies, making a complaint filed in court or government office vulnerable to a motion to dismiss. However, there are instances where the subject matter of a dispute is not covered by the law. So the following cases to be enumerated need not go through barangay conciliation as a precondition in filing a complaint in court or government office. So number 1, where one party is the government or any subdivision or instrumentality thereof. Number 2, where one party is a public officer or employee, and the dispute relates to the performance of his official functions. Number 3, where the dispute involves real properties located in different cities and municipalities, unless the parties agree to submit their difference to amicable settlement by an appropriate lupon. Number 4, any complaint by or against corporations, partnership, or judicial entities, since only individuals shall be parties to barangay conciliation proceedings, either as complainants or respondents. Number 5, disputes involving parties who actually reside in barangays of different cities or municipalities, except where such barangay units adjoin each other, and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. Number 6, offenses for which the law prescribes a maximum penalty of imprisonment exceeding 1 year, or a fine over 5,000 pesos. Number 7, offenses where there is no private offended party. Number 8, disputes where urgent legal action is necessary to prevent injustice from being committed or further continued, specifically the following cases. Letter A, criminal cases where the accused is under police custody or detention. Letter B, petitions for habeas corpus by a person illegally deprived of his rightful custody over another, or a person illegally deprived on or acting on his capacity. Actions coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property, and support during the pendency of the action. And letter D, actions which may be barred by the statute of limitations. Number 9, in the cases not covered by the Katarungang Pambarangay law, any class of disputes which the President may determine in the interest of justice or upon the recommendation of the Secretary of Justice. Number 10, where the dispute arises from the Comprehensive Agrarian Reform Law. Number 11, labor disputes or controversies arising from employer-employee relations. And finally, number 12, actions to annul judgment upon a compromise which may be filed directly in court.
Good evening, everyone. My name is Kate Alferin Silapira, and for tonight, it is my part to discuss the Katarungang Pambarangay procedure. Now, as part of the procedure, we should discuss the parties and venue when we talk about the Katarungang Pambarangay system. Now, it is provided in Section 410 of the Local Government Code that upon payment of the appropriate filing fee, any individual who has a cause of action against another individual involving any matter within the authority of the Lupon may complain orally or in writing to the Lupon chairman of the barangay. Now, it is also provided under Rule 6, Section 1 of the Implementing Rules and Regulations for the Katarungang Pambarangay Law, or otherwise in relation to Republic Act 7160, otherwise known as the KP Rules. It is also provided that only individuals shall be parties to these proceedings, either as complainants or respondents. So, no complaint by or against corporations, partnerships, or other juridical entities shall be filed, received, or acted upon. Individuals, as ruled upon by the Supreme Court in several cases, means natural persons. Therefore, the KP law and the rules, as I've mentioned before, do not cover juridical persons. Now, let's go to the rule on personal appearance. Now, when we talk about the personal appearance of the parties in the Katarungan Pambarangay system, personal appearance of the parties is mandatory. Therefore, in all Katarungang Pambarangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be assisted by their next of kin who are not lawyers. Next is the discussion on the rule on venue. Now, with respect to the rule on venue, here are the foregoing rules. Now, for disputes between persons actually residing in the same barangay, it shall be brought for amicable settlement before the lupon of the said barangay. Those involving actual residents of different barangays within the same city or municipality, it shall be brought in the barangay where the respondent or any of the respondents actually resides at the election of the complainant. Third, all disputes involving real property or any interest therein shall be brought in the barangay where the real property or the larger portion thereof is situated. And lastly, those arising at the workplace where the contending parties are employed or at the institution where such parties are enrolled for study shall be brought in the barangay where such workplace or institution is located. Now, in summary, it is provided therein that cases should be filed in the place where the respondent actually resides, or it is known also as the respondent's actual residence rule. And second, the place where the respondent's real property is located, or the real property location rule. Uh, third, common workplace of the parties, or the common workplace rule. And lastly, common place of study on place of study rule. Okay, now let's go to the actual system, actual Katarungang Pambarangay system. Now we start with the filing of complaint and payment of filing fees. Okay, so when we talk about the commencement of proceedings for settlements, it shall be commenced by verbal or written complaint to the punong barangay on any matter not accepted under Section 2 of the rule. In accordance with the rule on venue I have earlier discussed, and upon the proper payment of filing fees in the amount of not less than 5 pesos nor more than 20 pesos. Now, I already discussed earlier who may initiate the proceedings. It is provided therein that any individual who has a cause of action against another individual involving any matter shall have the right to initiate proceedings in the Katarungang Pambarangay system. Now, looking at the flow chart, it is provided therein that within the next working day, there will be the issuance of summons to the defendant. And not later than 5 days, there will be mediation. Now, in mediation, there could be two results, wherein first, the parties agreed to arbitrate, therefore, there will be arbitration. And second is after 15 days, there could be a settlement between the parties. So if yes, there will be the execution of the said settlement, and then there will be the transmittal of settlement and award to local, city, and the municipal court. However, if there is no settlement, there will be the constitution of the pangkat. And in not later than 3 days, there will be conciliation. Now, in the process of conciliation, there's also the option wherein both parties could agree to arbitrate. Now, when we talk about the arbitration process, there would be an arbitration, and in not later than 15 days, there would be an arbitration award. And then, if there would be an arbitration award, there would be an execution of the said award after 10 days, and it is enforceable within 6 months. And then within 5 days, there will also be a transmittal of settlement and award to the local city or municipal court. However, if the parties do not agree to arbitrate, after the conciliation, they will be given 15 to 30 days to provide for a settlement. Now, if they do agree to settle, same with the settlement after mediation, there will be an execution and transmittal of settlement and award to the local city or the municipal court. However, if there is no settlement, they would be issued a certificate to file an action before the court, which I will provide in the next slides. So now let's go to the Katarungang Pambarangay forms. Now, this first form talks about the what we will see if we will file a complaint before the Lupong Tagapamayapa. And this is the form where we fill up if we will file a complaint. Next is another form if we will undergo mediation proceedings, because as I have mentioned earlier, the first step would be mediation, and if they do agree to if they do agree to arbitration, there would be another form for arbitration proceedings. Now, if they do not agree to arbitrate and there is no settlement, there will be the constitution of the pangkat. And this is the form that we will see, which is a notice for the constitution of the pangkat. Now, as I've mentioned earlier, if we have the conciliation proceedings, this is the form that we will see if there will be a notice of such conciliation proceedings. Next, if both in mediation and conciliation, the parties agree to an arbitration, they will be given this form, which is an agreement for arbitration. It is provided herein that they agree to submit their dispute for arbitration to the punong barangay or pangkat ng tagapagsundo and bind themselves to comply with the award that may be rendered thereon. And that they have agreed fully with full understanding as to the nature and consequences of them submitting their dispute to arbitration. And now this is an example of an arbitration award, another Katarungang Pambarangay form, which is very relevant when we submit ourselves to arbitration. And then this is another form if in the process of mediation or conciliation, there is a settlement. This is the form that we will see. And then if after conciliation and there is no settlement, they will be issued a certificate to file an action before the court. And then after presenting such certificate to the court, they may now file their case before a civil court. So that is the end of our report. Again, we are Group 9. And the earlier, in behalf of the earlier presenters, Ms. Colliantes Carmela, Mr. De La Cruz, Arthur Michael, and myself, Lapira Kate Alfevern, And Miss Jaira Rodriguez, we thank you very much for listening to our report.